Welcome to the AskJunior Daily Judgment Podcast. I'm Priya Matthews, and joining me today is Arjun Chen.
Hello, everyone. We're excited to dive into today's important judgment. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now, let's get into today's fascinating case of HPCL Bio-Fuels Ltd. versus Shahaji Bhanudas Bhad, which brings up some really interesting questions about arbitration law and limitation periods.
Absolutely, Priya. This is quite a complex case that deals with multiple legal issues, from the interplay between arbitration and insolvency proceedings to questions about limitation periods and the withdrawal of legal proceedings. Why don't we start by laying out the basic facts for our listeners?
Good idea. So essentially, this case revolves around a dispute between HPCL Bio-Fuels Ltd., a government company that manufactures biofuels, and a contractor named Shahaji Bhanudas Bhad, who supplies equipment for sugar factories. Between 2012 to 2013, HPCL awarded several contracts to Bhad for enhancing the capacity of their sugar plants.
Right? And things started going south when HPCL expressed concerns about slow progress, quality issues, and missed timelines. By 2014, there was an outstanding payment dispute of about 18.9 crores that HPCL refused to clear due to these performance issues.
What's really interesting is what happened next. Bhad first tried to resolve this through arbitration in 2016, then withdrew that attempt and tried going through insolvency proceedings instead, before finally coming back to arbitration years later. This created quite a legal tangle for the courts to unravel.
Indeed. For our listeners who might not be familiar with these terms, let's break down what arbitration and insolvency proceedings mean. Arbitration is basically a private dispute resolution method where parties agree to have their dispute settled by an independent arbitrator rather than going to regular courts. It's usually faster and more flexible.
While insolvency proceedings under the IBC, that's the Insolvency and Bankruptcy Code, are quite different. They're aimed at either helping restructure companies that can't pay their debts, or if that's not possible, helping wind them up in an orderly manner. It's not just about recovering money, it's about trying to save the company if possible.
The key legal question here was whether Bhad could file a fresh arbitration application in 2022 after having withdrawn his earlier arbitration application in 2018. The Supreme Court had to consider several important legal principles.
Let's break down the three main issues the court considered. First, whether you can file a fresh arbitration application after withdrawing an earlier one without getting specific permission from the court. Second, whether the fresh application was time-barred. And third, whether any delay could be excused under the Limitation Act.
The court's analysis on these points is fascinating. On the first issue, while technically the Civil Procedure Code's rules about withdrawal of suits don't directly apply to arbitration, the court said the underlying principles should be extended to arbitration proceedings too.
They basically said that if you withdraw an arbitration application without getting permission to file a fresh one, you can't come back later with a new application for the same dispute. It's about preventing people from abusing the legal process or forum shopping, trying different courts until they get a favorable result.
The court was quite critical of Bhad's conduct here. They noted that he withdrew his arbitration application not because there was any defect in it, but because he wanted to try his luck with insolvency proceedings instead. When that didn't work out, he tried coming back to arbitration.
Right, and this brings us to the second major issue, limitation periods. For our listeners who might not be familiar with the term, a limitation period is basically a time limit within which you need to file your legal case. After that period expires, you generally lose the right to bring that case.
The court confirmed that for arbitration applications, you have 3 years from when the right to apply first arose. In this case, that meant Bhad's fresh application in 2022 was well outside the limitation period, which had expired in 2019.
Now, Bhad tried to argue that the time he spent pursuing the insolvency proceedings should be excluded from this calculation under Section 14 of the Limitation Act. This is where the court's analysis gets really interesting.
Indeed. Section 14 allows courts to exclude time spent pursuing the wrong legal process when calculating limitation periods, but only if you were pursuing the same relief. The court made a crucial distinction here between arbitration and insolvency proceedings.
They emphasized that while both proceedings might ultimately result in some recovery of money, they're fundamentally different in nature. Arbitration is about resolving a specific dispute between parties, while insolvency proceedings are about either rehabilitating a company or winding it up in an orderly way.
The court also made an interesting observation about the nature of insolvency proceedings. They cited several previous cases to emphasize that the IBC isn't meant to be a mere debt recovery mechanism. It's about resolving corporate distress and trying to keep viable businesses alive.
This distinction had important implications for Bhad's case. Since insolvency proceedings weren't seeking the same relief as arbitration, the time spent pursuing them couldn't be excluded under Section 14 of the Limitation Act.
The court also considered whether they could excuse the delay under Section 5 of the Limitation Act, which gives courts discretionary power to condone delays if there's sufficient cause. But given Bhad's conduct in strategically abandoning arbitration to pursue insolvency, they weren't inclined to exercise this discretion in his favor.
This judgment really emphasizes the importance of choosing your legal strategy carefully. You can't just hop from one forum to another hoping something will stick, and then expect courts to excuse the resulting delays.
The court was also careful to address one final point, the fact that in an earlier order, they had mentioned that Bhad could pursue other remedies, including arbitration. They clarified that this wasn't a blank check to file proceedings that were otherwise barred by law.
This case has significant implications for future litigants. It clearly establishes that you can't file multiple arbitration applications for the same dispute without court permission, and emphasizes the importance of adhering to limitation periods.
It also provides valuable clarity on the distinction between different types of proceedings. Just because two different legal processes might ultimately result in some monetary recovery doesn't mean they're seeking the same relief for the purposes of limitation law.
And that wraps up our analysis of today's judgment. We hope our listeners found this discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Matthews.
And Arjun Chen, signing off. Thanks for listening to the Ask Junior Daily Judgment Podcast.